Okay, why don't we get started? Good morning, everyone. My name is Bart Oosterveld. I'm the Boyd and Gray Fellow of International Trade and Economics here at the Atlantic Council and the Director of the Global Business and Economics Program. Welcome. We did not know when we were planning this event that Mark Zuckerberg was going to be on Capitol Hill yesterday and today, so we were unexpectedly prescient about picking this topic, and I hope we'll have a very good conversation here this morning. We certainly have the panels lined up to do that, and we look forward to your questions and participation. The event today is part of our EuroGrowth initiative, which tries to identify policy best practices conducive to growth on both sides of the Atlantic. I want to flag for this audience real quick some things we're doing next week, coinciding with the spring meetings of the IMF and the World Bank. A week from Friday, on April 20th, we will have a panel with the finance ministers of Latvia, Sweden, and Norway, all of them women, to talk about financial inclusion of women and girls, and that's going to be a critical discussion and a very timely event. It will be moderated by our board member, Laura Lane from UPS. We will also, next Thursday, so a week from tomorrow, host Mario Centeno, who's the new president of the Eurogroup, the meeting of the European finance ministers, and the new chairman of the European Stability Mechanism, and his first public address in the United States since taking the position. So you will see those public invites, and I hope many of you will be able to attend. But first, let's talk about data privacy. And we have an excellent panel convened here today. And again, in light of the recent Facebook and Cambridge Analytica news and the upcoming going into effect of the GDPR in Europe on May 25th, this is a particularly timely topic. And let me start by introducing our panelists for today. Kara Sutton, to my immediate left, oversees the U.S. Chambers of Commerce of work on digital policy with an emphasis on global data privacy and data transfer policies, and she will come with that perspective. Next to her is Fran Burwell, who's a senior advisor at McLarty Associates and a distinguished fellow with the Future Europe Initiative here at the Atlantic Council, and an expert on the EU digital single market strategy. And then finally, last but not least, all the way to my left is Peter Fatelnik. He's the counselor for the digital economy at the delegation of the European Union here in Washington, D.C., and promotes cooperation on digital regulation. So with that, please help me welcome the panelists, and we'll go into our first panel. Peter, if I could start with you. The GDPR is going into effect after a 2-year grace period this upcoming May 25th. And there's been a lot of coverage about some of the aspects of it that a lot of people like privacy, data portability, and consumer control of data, as well as harmonization of a patchwork of regulation that existed beforehand. And then there's been some hand-wringing around compliance costs, especially for smaller business and the like. Can you give us an overview kind of from your perspective, from the business perspective, and from kind of the perspective of this going into effect pretty soon?
Many thanks, Bart. You used the word grace period. I like that. I've never heard it before. Well, the grace period basically means, it gives the companies the opportunity to implement the changes of the rules. So this is what everybody has been doing the last 2 years, and will probably keep on doing for the next few years, and not only up until 25th of May when the regulation goes into force. Now, I think for a business it's important to really recognize that this is a customer demand. Customers demand data privacy, and I think it would be only natural that businesses heed to customer demands. What the GDPR does is a recodification of that value or that demand customers have across Europe, and probably not only across Europe. We see that the value of data privacy is being cherished in many other regions of the world, and you didn't want to make a reference to the conversation of Mark Zuckerberg yesterday in the Senate, but that's another opportunity to see that what is the value of data privacy and how is that cherished in different regions of the world. So It is very important that that companies understand that this is not a compliance, this is not a burden, this is more of an opportunity. And I sort of would like now to elaborate a bit, because I think I have taken my mouth quite full when referring as an opportunity here. There are two major changes this GDPR brings. First, I think everybody knows there are existing data privacy regulations and rules across Europe. So we are not talking about a greenfield story here. There is a lot in place already, and what is coming now is actually a simplification. And probably the biggest vectors of simplification are the one of one continent, one law. I think that's a really major simplification. I mean, imagine if you're a company operating across Europe, you would have so far to comply to all the national data protection regimes in the different countries, and those who are the fine connoisseurs of Germany know that actually within Germany there are also regional differences. So it's not the most easy way to navigate that. So one continent, one law gives also this business security and certainty and clarity for business, which they demand. I don't think business cares very much sort of whether the rules are green or blue, as long as they know it's green or blue. The second major simplification is around the data protection authorities. So far, in every country you operate, you would have to deal with the data protection authority. Now you will only be accountable to one as a company. No matter in how many countries you operate, there is a rule which determines which one this is. In many cases, you can actually choose. And that will as well obviously cut down tremendously the compliance cost, the reporting cost, and also the cost in communication. Because the European Union has so far 23 languages, so for the major businesses, this was certainly not an easy operation and a direct cost. So actually we went, before we published this new GDPR, we went and estimated the savings through just these two lines of simplification for business. The savings are $2.8 billion per year, just because people don't do things they are doing today, and which probably actually don't have much value, on the contrary. Now, this is simplification. I think everybody likes that. That's a simple story. I would like to sort of, in my introduction, to move to a conversation which is maybe lesser well known. There are two more parts of this GDPR which I would like sort of to advertise here and see them more as the business opportunity I was referring to in the beginning. The one is on data portability. Yes, the GDPR increases requirements for customers being able to retrieve the data, retrieve them in a meaningful format and in a meaningful way. Now you have to see that from another business perspective. If you are a young company, a startup company, you can go now to your customers and say, well, if you're a customer over there, why don't you just retrieve your data? I help you to import them in my system, and from now on we work together. So you also have to see that from the market perspective. Yes, one company may lose a customer, another one may gain a customer. So what it creates is a more liquid market for those personal data. And people then can more easily shift around. Now, of course, I'm sort of simplifying because the devil is always in the detail. I mean, data, export, import, I mean, that's a non-trivial thing. But business is good in solving these solutions. So I'm not necessarily worried that businesses will not come up with business models with the technologies necessary to support such changes. But the GDPR gives now this opportunity and the incentive to do so. Another line which is more forward-looking is, and this is, I think when the Commissioner Jourova talks a lot, she really emphasizes that point, is this privacy by design. It's also that we have to move away from this kind of privacy, data protection as simply cost. No, they're not cost. They're not like raw material cost in any company. They are a cherished value. So then if we want to move ahead, we have to recognize things have to have privacy and data protection by design, by default. This is sort of the level playing field. There's no question about that anymore. Now, what we would like to enable here as well, then more technologies which go into pseudonymization, anonymization, or encryption. So which again is, for companies, an opportunity to differentiate their product. And closing a bit my introduction, I think with what Bart said with compliance, we're not asking for compliance. Compliance in regulation is an obvious given, but probably the opportunities in over-compliance, in doing better than what the standard is, and then advertise that as a business advantage, saying, you know, we do GDPR, that's obvious, everybody does it. But we also have encryption, we have pseudonymization. Look here how good we deal with your private data. And with this, I would like to leave it a little bit.
Very good.
Thank you.
Thank you, Peter. Fran, let me ask you to respond to that.
Well, let me just say that I've certainly noticed one particular business opportunity, and that is the number of companies that are now advising companies on how to implement GDPR. So a whole new field of business right there. I wanted to broaden the conversation a little bit. I think this has been a very interesting and good summation of GDPR as an opportunity, and I find myself as someone who has always very much valued privacy, that there's a lot to like in GDPR, both from business and from the individual point of view. But I think when it comes to the United States, there's some intersections that are not clear. And I think that for any business in the United States, trying to figure out where does GDPR fit, there's some interesting questions, and I'm not going to have answers, but I just want to raise them. First off, I think, how does this intersect with Privacy Shield? US privacy rules as they exist independently are not deemed adequate by the EU for the transmission of data, as I would bet everyone in this room knows. And so therefore we have negotiated Privacy Shield, which allows companies to self-certify. I think there are close to 2,000 companies now that have self-certified that they meet certain standards. I would point out that the Privacy Shield is not so much a negotiation between the United States and the EU about what standards will US companies meet, but rather how will they meet them? Under what timeframes, how will they demonstrate that they've met them, et cetera. So as we look at these, at Privacy Shield for the future, what are some of the questions that GDPR may raise? Well, first, we did have the first review, and although the US made it through the first review, there are still some serious issues, particularly in terms of personnel and oversight, that have not been resolved, and I think that the patience of the Commission on our second review is likely to be reduced. So there's a potential issue there. There is also the fact that Privacy Shield is under legal challenge in the EU and has been very much criticized by some of the data protection authorities. Throw GDPR into this mix, and you have the possibility of the standards, do they increase? You know, the standards under Privacy Shield were based on pre-GDPR. So over time, I'm not saying immediately, I'm not saying like next year everybody has to, what do the companies that want to self-certify, do those have to be increased in order to meet the privacy requirements that will preserve it from having the same end as safe harbor and not being considered appropriate by the ECJ. So I think that's a big area of question, and if I were a company, I would be looking down the path. The question is not, do you go out and adopt GDPR, but more down the road, am I going to find myself heading to GDPR because I'm already in Privacy Shield and I'm going to have to think that way anyhow? And I don't have an answer, but if I were doing this in a company, I would be alert to that. I think there's a lesson to be drawn from this, although this lesson may change in the wake of the Zuckerberg hearing. The US has been much more passive on regulation in this area, whereas we've been focused more, I would say, on transparency. So we have long informed consumers about breaches. That doesn't mean we fine companies anything like GDPR will for breaches. If you look at the current debate about Facebook and politics, what you really see is a proposal that Facebook and others be more transparent about who's paying for certain ads. Not that the ads would necessarily be restricted. So I think that this has been our approach, and it's a very different approach from the EU approach. I was struck by the fact, since I also work on trade policy, that we're used to the US going to Europe and saying, you know, you have to be more open for GMOs and things like that. And now we're facing the opposite kind of, where the EU is coming here and saying, you have to pay attention to these privacy rules. And we're not used to being in this situation. I think this passivity in regulatory policy may actually change a little bit in the wake of the Cambridge Analytica. Where can you pass data on to? How do consumers know where their data is going? Several steps down the line. But I was struck by Peter's first statement of privacy as a consumer demand. And I would say that in the United States, it has not been anything like that as it is in Europe. There are places where it is. Perhaps it will become that now that people are looking at what happened in terms of Facebook. But I frankly, I don't know whether this is a wave that we will get over the crest of and then everything will calm down and consumer demand will lessen. But there's not an attraction to privacy as a fundamental right as there is in Europe here. And I think that we have not had the conversation that Europe has been having for several years. We're just starting it, and I don't know if it's going to create more demand up on the Hill and other places. And I do not see this administration leading the charge. If it's going to come from anywhere, it's going to come from Congress. Then I would say, how does GDPR intersect with law enforcement and the law enforcement use of data? We just passed the Cloud Act, making it possible for law enforcement authorities to go directly to companies to ask for data under certain circumstances. And the European Commission has a similar proposal to allow law enforcement to reach across member state borders. They have made it very clear that they would like to use that once it's done internally, that they would like to use that as a basis for a similar arrangement with the United States. So there's a conversation that needs to be held about how does the law enforcement use of data, how is that reconciled with GDPR? Do you just say it's law enforcement so it doesn't apply? Or are there certain conditions, and how do you define those conditions under which law enforcement has the top hand, so to speak? And what happens to those inevitable errors that when too much is raked up and examined, and do we know that law enforcement is getting rid of the data that they're not using for prosecutions, et cetera? I think, particularly, will the EU trust that the US, with the Cloud Act, which I think generally we need to figure out this question, and the Cloud Act is a step forward in doing that. So I'm not saying we shouldn't have done the Cloud Act, but will the EU trust that when the US says it's law enforcement, that is not a violation of what the standards that they hope would be implemented under GDPR by when companies are made to give up data. So I think there's a conversation and an issue there. I would also say that we still have PPD 28 in effect, extending safeguards to foreign citizens. We now have a new national security advisor, and I think that I hesitate to bring it up because I don't want to draw attention to it, but I think that we don't know his views on things like this. So that's another area. And then finally, I would just bring up Brexit. The UK will adopt and implement GDPR because they are still a member of the EU. But I assume that will mean that when they leave, they will get an adequacy determination excuse me, for the transfer of data between the EU 27 and the UK. We don't know that. We kind of make that assumption. I assume that we will negotiate with the UK some kind of privacy shield arrangement that's similar to the one we have with Switzerland, for example. These can all be non-headaches. Or, given the way Brexit has been going, they could be more complicated. So for businesses that are doing business both with the EU 27 and the UK, where a lot of financial data gets transferred, I think there's another issue to kind of to look at there. So I'll stop there.
Thank you, Fran. Very, very thoughtful as always, and great topics for conversation. We switch to Kara to give the perspective from the U.S. Chamber of Commerce.
Yes, thank you. So I thought it was kind of interesting, the comment about privacy. I agree that I think privacy is a consumer demand, but I disagree. I don't think GDPR is necessarily a consumer demand. And I also, Fran's comment, I was going to kind of open with the same thing, that this has been really job security for me, being able to talk about GDPR all the time. So it has been an opportunity that sometimes regulation creates jobs. But I think for companies, while we can talk about, it might be an opportunity or an issue, for companies it's just a reality now. May 25th is about a month away. Companies are spending millions of dollars on trying to figure out how to come into compliance with GDPR and make it happen. And I also think that it's important to note that this kind of grace period also applies to countries. And what has been problematic right now when I look at GDPR is there's a lot of uncertainty, and a lot of that uncertainty is that there's only 2 countries really out of the 28 member states of the EU that have the derogations in place and the implementing legislation around GDPR. And since GDPR is a regulation, it'll branch off across all member states, but there are certain parts of GDPR, especially around children data, where member states have the authority to change what age, whether it be 16 or another age, in terms of they can create that in their implementing legislation. So not having that in place by May 25th when a company is expected to comply, having that could potentially change. It makes it very difficult for companies to have kind of their compliance models in place. And then I think just in general, GDPR has created a lot of uncertainty for business going forward. There's a lot of questions. It introduces this idea of extraterritoriality, where you as a company, you may have no actual physical presence in Europe, but if you process European citizen data, then you are subject to GDPR. And I've worked with a lot of small businesses that, they're based in Philadelphia or in the Caribbean or somewhere else, and they handle a small amount of EU data, and they're like, we have no idea what this law is or what we do or how we comply. We're a 3-person team. One of them is a travel agency that books trips for Europeans when they go to the Caribbean, and they're really trying to understand how to comply. So it's obviously for a small business taking a lot of that time where they would be, trying to reach out to more customers or spending money on marketing to kind of keep driving customers to them. They're instead hiring legal teams and figuring out how to put in place compliance mechanisms. So I think that's one issue. I think at the heart of it, I think we can all agree with some of the principles of GDPR that's also rooted in US privacy law. And a lot of times I hear from Europeans, the US doesn't have privacy law. That's really not the case. We do have privacy law here in the US. And just like the European GDPR, it's really rooted in this idea of transparency, fairness, and accountability. And I think that we share that on both sides of the Atlantic. And I think other countries that are looking at privacy laws, we all kind of start from that same place. But where we get kind of lost, I think, is really when we go down the road of implementation. And I think, first of all, when you look at GDPR, it has a very broad scope, the way that personal data is defined. So we've been talking with a lot of security companies, for example. Under GDPR now, IP addresses are considered personal data. And so we are hearing from a lot of security-based companies that when they have to share information about an IP address, they're having difficulty understanding how they're going to be able to do that with one another when they have to share that information with another company, especially in the financial system where a lot of banks work together to warn each other of potential bad actors. So that's creating some issues within kind of different sector by sector when we look at GDPR and the scope. It's also creating a lot of issues for our companies who deal with the ICANN Whois database. And so the Whois database is used for security purposes and then also really content creators. And it's basically a database where a company can go and see, if someone is a bad actor or infringing on copyright. And now with GDPR, there are going to be some limitations on access to that database. So those companies that have a legitimate reason to access the database may be blocked from it, which will have security implications and then, of course, IP implications as well. And so those are just a couple of issues that I see with GDPR. And I think the biggest issue that it creates is really the siloing of data. So as part of GDPR, countries have to be deemed adequate in order for data transfers to take place, which is why we have the privacy shield between the EU and the US. And I think this creates greater challenges, especially as more and more countries kind of look at this adequacy model. Data really knows no borders right now. Data flows, it doesn't stop because it ends at the US. But what we're doing by creating these sort of adequacy decisions is we're siloing data so that only a certain amount of data can be in the US, only a certain amount of data can be in Europe, only a certain amount of data can be in Brazil. And by doing that, I think we really limit the ability of companies to be innovative. We limit the ability of startups to easily access foreign markets. And so I think kind of pursuing a route of adequacy can be very problematic. And for example, if you take the Japan-EU negotiations, those have gone on for about 1.5 years now. And I think they're coming to an end soon, but to be able to have to go and negotiate with every single country a privacy shield or an adequacy decision creates a lot of problems when it comes to cross-border data transfers for companies that, you know, they want to be able to operate in other markets, but if they're not able to transfer their data, they can't get their goods there, they can't get their services there, and so it just makes it much more difficult for companies to operate. And so those are just a couple of issues that I see and some uncertainty that I see. And we've really been trying to work with the European Commission and then the different data protection authorities to really address some of these issues going forward, especially with the May 25th deadline. And I think one of the biggest challenges that we'll see, I guess 2 challenges that I see going forward that I think we especially need to pay attention at the May 25th deadline and after is really one on data breaches. So the GDPR has a pretty stringent 72-hour data breach timeline, but the GDPR language also gives leeway that, you know, undue delay and where possible report within 72 hours. But I think what we could easily see in Europe is kind of the DPA, the data protection authorities, getting kind of a ton of data breach notifications and basically getting swamped with data breach notifications and not really having a clear way of how to handle those. And so I think that's going to be one issue off the bat of how our DPA is going to deal with that. And then I think secondly, you know, we support generalized regulation in Europe. We think that pursuing a route of regulation does create a much more harmonized approach that makes it easier for companies to operate. But it really all comes down to enforcement and implementation. And I think, you know, there's going to be this European Data Protection Board created, which I think is a good step to make sure all the DPAs are on the same page. But I'm already kind of starting to hear differences from different DPAs. So I hear from some DPAs that as soon as the May 25th deadline hits, they just still want to work with companies. They're not going to start fining right away and searching for past data breaches that have happened. And then I've heard from other DPAs that as soon as May 25 hits, they're going to start looking at this and making sure companies are complying. And so I think making sure that DPAs are enforcing this in the same way across the EU is really the only way to make the regulation work. And I think the European Data Protection Board will have a really big role in making sure that it is truly harmonized across the EU.
Excellent. Thank you, Kara. I think all 3 of you have raised enough topics for a series of panels, which we don't have the time for today. There's some things in each comment that I think beg a question of another panelist. So let me do that, and I'll start with Peter. Peter, without charging the topic too much, I think you heard from Kara kind of concerns, especially for smaller enterprises. And we don't need to get into extraterritoriality right away. We just talk about also within Europe compliance costs. I know you don't love that term, but the reality of dealing with this new framework for a smaller enterprise. And my recollection goes back to Dodd-Frank, which you can look at through a variety of prisms, but one of them is it greatly benefited larger banks and through a barriers to entry for smaller financial market players. Is that, I know that's criticism you've heard, is there kind of an answer that the Commission has, and how has that been thought through?
I think in this conversation, you know, when we talk about business, you know, business could be a very large IT firm, but could be equally a plumber down the road. Mm-hmm. And in Europe, we have a lot of plumbers. So there are 23 million small and medium enterprises across Europe, and many of them are not in the business of data and digital. Most of them are in the business of delivering other goods and services to their customers. And particularly for those smaller operators, there are exemptions in the GDPR in terms of the appointing of a data protection officer and also in terms of reporting. But they're not exempted completely, because also if you are a plumber, I think we would like to make sure that you understand that you deal with private and personal data, and you will have to put certain safeguards into place in operating those customer databases of the, I don't know, 200 people you serve or whatever. So in that sense, so the exemptions are really geared towards those sort of companies. But you could be a startup, dealing with a massive amount of data. And this is sort of where exceptions should not apply, because this is where the risk is high that something goes wrong. It's also sort of, these exemptions are essentially, the idea is of a risk-based. If there's low risk, you may as well have exemptions. But not that I want to push back on some of the things which have been said. I think here, sitting in Washington, D.C., having this conversation, we also have to realize that for the people sitting back in Brussels or in Europe, the US may be a super important trade partner, but not the only one. And this extraterritoriality is super important to that, because if you're a company in Germany, you're most likely to have customers in Norway or subsidiaries in Norway or Switzerland, and you work with them, or the other way around. Most, I wanted to say, a very large part of the European population goes on holidays to Turkey. So there are huge Turkish tour operators. We want to make sure when they deal with data of Europeans that they apply certain quality standards, and these are the GDPR. So don't sort of feel singled out here in this treatment. It sort of concerns many countries, because indeed Europe has been a free trader for many years, and the result of it is that we have free trade in goods and services across the world. And what we see here in the GDPR is sort of a representation of that trade map. But,
okay, thank you. Thank you. That's very helpful. I ask a question of Fran first. First, Fran, I saw you nodding when Kara was talking about data breaches, and I wondered if there's anything else you want to discuss about that. But then the question I had for you is, and I'll ask the same question to Kara later, so you get a preview. It's not like 25 May is suddenly here, right? We've known that this has been coming. This is it's not scheduled like the World Cup soccer, but we've known for a while that this was around the corner. Are there, you mentioned consulting opportunities and helping companies implement. What kind of templates are there, especially for the smaller companies? What kind of standardized implementation is there? What kind of guidelines, either provided by the public sector or as a private sector opportunity? Because listening to radio in Europe, you now hear commercials on the radio about we'll help you implement. Yeah. It seems quite late in the game. And so let me ask you to comment on those topics.
Well, I think it's true we've known about May 25th for a long time. But particularly when you talk about the smaller companies that don't have big legal teams already, they are most likely to be the ones that are the least aware. I would also, going back to Peter's example of a new startup in the technical area that is making money out of a lot of data, and yet we have all seen time and time again, and we can look to Facebook for this as an example as well, how the leadership in those companies really has absolutely no idea about regulation until they get to be significantly bigger, and usually learn about regulation by running into some kind of regulatory issue, right? So there was a long time here in this country where the people in Silicon Valley were like, Washington? Why do we need to pay attention to Washington? And actually, I think they learned first about Brussels before they learned about Washington. But so I think we will see a gradual implementation. I took Kara's point that 2 member states have done all the necessary homework. I think in Europe it will be gradual, and I think that the DPAs that are looking at immediate implementation are going to find themselves being viewed as unreasonable by their own business community. On the other hand, I have a lot less sympathy for the big companies that have reams of lawyers and have been looking at this. I would hope that the car companies who now are processing all sorts of data about your location and all that kind of stuff. So it's not just tech companies, but any of these companies that they should already have figured out what they're doing with that data. I have a lot less sympathy for that. Here in the United States, I think that it's going to take a couple of eye-opening moments, and I fully expect that there will be a couple of big fines in the next year. And that's when people will really start to pay attention. As for the specific templates, I don't know. I just, like everybody else who is looking at this stuff, I see ads for companies that you sign up for a certain amount per month, and they will make sure that they'll tell you how to comply. They have templates for you. When there are updates, they'll make sure that you update. And some are good, some are bad, I'm sure, with due diligence, but probably for a lot of small companies, that's a better way to go than actually hiring a whole legal team. So, but I do think that what we are about to see, the 25th is important, but it is not going to be like suddenly you walk into a whole new environment.
Thank you, Fran. So, Kara, same question for you. And then if there's other comments you want to make around what the Chamber is doing around this implementation, if there's anything you're doing for the membership, that would be great to know as well.
So I want to pick up quickly on a point Peter brought up, that on the extraterritoriality, that it's not singling out the U.S. And I think that's a very important point as well, that Japan, China, every country around the world that has companies that operate in the EU has to follow this too. And I think that's important when we consider the enforcement and the implementation, because I think what I hear a lot is a concern that American companies are automatically going to be the first target. I think we have to look at other companies around the world as well that may not be compliant. Because from my perspective, seeing what our companies have been doing to comply, they've been working very diligently to make sure that they're going to be in compliance by May 25th. And even companies, so companies like IBM, Microsoft that we work with, especially cloud providers, have really created ways for the small businesses that use their services to also be in compliance with GDPR. And so I think that's an important kind of business-to-business relationship that they've really set up there to make sure that they can help ensure that anyone that's using their cloud knows that they're in compliance with GDPR and it's a secure cloud. So I think that's one thing that's been helpful. The European Commission also came out with guidelines for small businesses that I point a lot of smaller companies in the direction of. And while they don't answer all of their questions right off the bat, I think things like that are really important for the Commission and then of course the member states to do, to really kind of reach out to small businesses and advertise those tools that can be helpful, so that maybe they don't have to lean on some sort of legal team, or they don't have a legal team to lean on. So I think those are some examples of things that are going in the direction of helping companies comply. But I think overall, kind of on the enforcement stage, I think Fran really hit the nail on the head that May 25th, fireworks don't go off and it's like everyone's ready to go. This is going to be a continuous process, and I think throughout the years we're going to see what GDPR looks like change, how it's implemented will change, how businesses react to it will change. And one of the things too that I get asked a lot is like companies that may be implementing GDPR across the board. And I think Peter mentioned this too, it's not just tech companies, it's a comprehensive piece of legislation, or comprehensive regulation. So it goes to companies that are retailers, goods providers, food and beverage companies. And so for each of those companies, there are different compliance issues to each one. So while some companies may be able to say, okay, we can easily implement GDPR across our entire system and make it available not just to your EU citizens, but everyone else. But a lot of companies that I work with, they especially tailor their services or products to particular companies. So in that sort of situation, it makes it a little bit more difficult to kind of expand GDPR across a broader array. And so I think what we could end up seeing from some companies even is that you potentially end up having a difference between the products and services that are offered to European citizens versus what may be offered in the US or the rest of the world.
Okay. Thank you. Not too dissimilar to financial services and other regulated. Peter, just making sure, are you planning fireworks on the 25th?
But I like that comparison because it's fireworks to kick off the party, and the party is only going to take place after.
We have about 10 minutes for Q&A. Yes, sir, over there. There's a mic coming around.
Thank you. Andrew Falone with the Embassy of the Principality of Liechtenstein. Norway, Iceland, and Liechtenstein were all lucky enough to become members, become subject to the regulations of GDPR this coming May as members of EEAA. But for states such as Switzerland and Israel that have closely modeled European data regulations, yet not necessarily been party to them, do you think that there's expansion possibility for GDPR outside of the EU? And if there were such expansion possibility, do you think that they would have representation on the European Data Protection Board? Thank you.
For Peter, I assume? Yeah.
There's a certain speculation in that question. As a principle, we are not walking around the planet and advertising the GDPR as a model for others to do their business. So this is not what we are doing. Now, you are right that many countries have similar provisions in place. Many countries, and I take another example in India, there are conversations ongoing about adopting an Indian-wide data protection regime, may be inspired by such regulation. Now, I wouldn't say copying regulations from one country to another is a very good and very old practice in several hundred years, so it's nothing new or shameless to do. I think it's a good practice in general. So we would expect that probably many people take a leaf out of the GDPR and use it within their own framework. But certainly we were not looking at the standardization kind of attempt and a level playing field à la lettre here. The second question is representation on the European Data Protection Board. That's clearly out of question for the moment. However, this is maybe where I can add. European regulations have review clauses, so normally we review them fairly frequently. There will certainly be an opportunity within I would now guess a little bit, 3 to 5 year time frame where the Commission will go back. Did it work? What has worked? What didn't work? What do we need to change? I cannot foretell what they will really do at that time, but there will be that process, and that may change then the environment a bit. Thank you.
Fran, comments on that?
I was going to say, Peter said that they weren't going, that the EU wasn't going out and saying, adopt GDPR, et cetera, et cetera. But the reality is that the power of the European market and the extraterritorial provisions make it something that people have to think about and make this, I think that we will see more and more companies adopt GDPR in the absence of their own legal framework or in the absence of a framework that is as tough as GDPR, because it's the way that they can deal with Europe. And more in this economy, in this global economy, you have customers who are in Europe or let's call them data subjects who are in Europe, right, for whatever reason. And so I think that after an implementation period, after a trial period, let's say that, you may see more and more countries looking at GDPR and essentially copying the legislation because of the power of the European market. Now, the question then becomes, do they, if they're thinking about privacy regulations, adopt something that they feel is more specific to their own circumstances, but which may actually raise barriers or create conflicts with GDPR, or do they go for GDPR? And this is, I think we're going to see over the next few years a test of the draw of the European market and its, shall we say, soft power.
Okay, thank you. Kara, you indicated you had comments as well.
Just to kind of add to that, I think on the one hand, we are seeing a lot of countries already try and pace GDPR, but I think the problem with that is every country is different. We have different expectations for privacy. Privacy means different things to different people, and especially even having advanced rule of law. So in the EU, we had the 95 directive before, so there has been privacy legislation before. and there are these independent data protection authorities, and there's a system in place that really ensures the GDPR works. But for a lot of countries, just copy and paste it and implement it. If they don't have that sort of rule of law in place, then it doesn't really work in the same way. And what will end up happening is it's going to get fragmented. It'll play out in courts, and it'll end up being kind of a worse version of GDPR that's not effective at all. So I think that's one important aspect of it too, is that every country, while I think you can look at the US, you can look at GDPR, you can look at the OECD guidelines around privacy, you can look at the APEC cross-border privacy rules. Looking at these existing frameworks, I think, is an important responsibility for countries when they're doing their homework on what do we want to choose. But at the same time, just copying, pasting that doesn't work on a country-by-country basis.
Absolutely.
And one point that I want to make too is really on interoperability. And I think that's what the conversation is going to be as we look down the road. As more and more countries are creating privacy regimes, interoperability is going to be key, because data needs to move, companies need to do business across borders, and making sure that those frameworks are interoperability is really key to ensuring their success. And I think with GDPR, there's the certification scheme that's still under discussion. And I think that's a great opportunity to really ensure interoperability with the US system, and especially the APEC cross-border privacy rules system. So the APEC cross-border privacy rules allows APEC economies that have agreed to the rules, their companies can, there's 6 countries that are participating, so companies within those 6 countries can easily transfer data between those countries. And so I think that certification mechanism, there are conversations between APEC and the European Commission and the Article 29 Working Party right now that are looking at how can GDPR adopt similar certification scheme as APEC CBPR, and those conversations will be really important if they play out well, and could allow a company to easily sign up for APEC CBPR and then be able to use a certification scheme under GDPR. And then, as a customer, you are ensured that it doesn't meet, but not just one, but 2 kind of privacy frameworks.
Understood. Thank you. Let me see in the audience any more questions. Okay, seeing none, we're almost out of time. Peter, I know the answer to this question is no, but are there any further comments you'd like to make on Brexit, which is the topic that Fran raised at the beginning?
It's interesting. First, you're right. GDPR will apply, and Brexit and the latest conversation will only take place the 31st of December 2020. So it's still a bit of a time frame. You probably know that the Brexit bill, so the law which takes the UK out of the European Union, is a very short one, because essentially what it says is that all European regulations become national regulation. So per se, on the 1st of January, the GDPR will still apply in the UK. May have a different name, or you can call it whatever you want then. And we would probably expect out of practical that things like this will not be changed immediately. They may be changed over the long run, but it takes a parliament a couple of years to go through a few thousand national regulations and change them to whatever they think is adequate. So probably for the foreseeable future, we are dealing in the UK with the GDPR, but that's sort of a business estimate, more than certainty.
Thank you so much. Please join me in thanking the panelists. We have coffee outside. Great.
Okay, so welcome back. Please take your seats. My name is Valerie Rouxel-Laxton, and I'm a non-resident senior fellow here at the Atlantic Council. And I'm going to moderate the second panel. The previous panel was actually on the value of data privacy. I don't know if all of you were there, but the second panel will focus on intellectual property rights in a changing world, so the value of intangible capital in a broad sense. Intellectual property, or IP, includes a broad variety of intangible creations, such as copyrights, patents, trademarks, for instance, artistic work like music or literature, some discoveries, some innovations, designs. All of these goods can be protected by intellectual property law. Intellectual property law is ever evolving, given the diversity of activities and the nature of these activities. And it's there to protect creators and encourage them to innovate, while at the same time stimulating or spreading the use of their creations. Intellectual property law is the framework. It's there to encourage creation of a large variety of inventions, a large diversity of goods. The legal framework gives the people, the creators, those who create, the businesses, a set of property rights to what they create, usually for a period of time that allows recouping the initial investment that they put into developing these innovations, so that they can earn something, an income or a profit out of it. And it provides thereby the economic incentive to creation and innovation. As a consequence, changes to intellectual property regulations may modify these incentives, one direction or the other, boost them or hamper them or limit them. Therefore, intellectual property regulations have implications across a number of businesses and specific sectors that are actually very broad and diverse. And it also changes the number of goods at the disposal of the consumer or the end user of these inventions or goods. In principle, one would try to balance rights so that they encourage creativity and innovation, but in a way that doesn't prevent the creation's wider use and avoids generating rents. Government authorities therefore face a quite complex set of choices on how to design IP systems, intellectual property systems for protection. And these pose questions of how best to innovate, how to respond to changes driven by technology, how to respond to changes in business models that are fast evolving, and that will challenge the regulatory practices that are in place and need to be evolving. So the underlying question is really one of valuing the worth of intangible capital. And the reason why we're having this discussion now is that it appears that countries do rethink periodically or revisit the rules of intellectual property in the context of a rapidly changing world, of rapid innovations. And I think we can all agree that right now we're going through such an era. For instance, as electronic online platforms develop very fast, as global value chains have changed the features of our production processes in manufacturing notably, or as rapid scientific innovations occur. For example, in 2016, the EU, the European Union, laid out two or three proposals actually to modernize its IP legal framework in response to evolving needs. And panelists here present today may want to outline what's happening in this respect also in the United States, what is happening or less happening or more happening here. People usually have two broad sets of interrogations when thinking about intellectual property. One is about innovation, about its dynamism, and because innovations make infringement of intellectual property rules difficult to trace, so they have this at the back of their minds when thinking about IP. So the questions rotate around how to mitigate the risks of infringements, how to evaluate the extent of the risks, how to devise strategies to provide more effective intellectual property protection to creators and innovators. So a whole set of such issues. The second group of people usually have in mind what is the impact of these potential changes in rules and regulations on investment, on incentives to innovate, on the location of production, on competitiveness, and by implication on trade. So joining me on this panel this morning, I have Sandra Easters, who is the director of the Copyright Research Policy at the Center for the Protection of Intellectual Property, hosted at the Scalia Law School of the George Mason University. Sandra has nearly 20 years of advocacy experience on behalf of intellectual property owners. Immediately prior to joining Scalia Law, Sandra was CEO of the Copyright Alliance, a non-profit public interest organization that represents the interests of artists and creators across the creative spectrum. She has private sector experience as well and began her legal career in a private practice. And then I have Mrs. Gina Viteri, of counsel at Covington and Burling law firm. Gina provides strategic and legal advice to clients on international trade and global policy matters. She counsels clients on the negotiation, implementation, and enforcement of bilateral and multilateral trade agreements, including in the areas of intellectual property, market access, regulatory trade barriers, online commerce, competition, and investment. She joined Covington after experience with the U.S. Chamber of Commerce and with the USTR, the U.S. Trade Representative. So I'll give Sandra and Gina 5 to 7 minutes to explain how they view this topic from a broad perspective and to zoom in and give us a flavor on how the specific sectoral approaches to these issues of IP play out. Who would like to start?
Either way, I guess since I'm the one with an A in the last name, I'm used to starting, so I'll do that.
It's always the negative of the B or positive.
So thank you very much for the introduction, and thank you to the Atlantic Council for inviting me to participate in this conversation this morning. I'll just start from a very broad, maybe philosophical perspective, talking about IP and why it's so important. And as you can tell from my background, I'm primarily focused on copyright issues. In the United States, intellectual property protections are enshrined in our Constitution, as most of you probably know. And as one of the few powers that are explicitly mandated to Congress, protecting intellectual property rights demonstrates how important the founders of our republic thought that intellectual property rights would be to the development of our nation and to the well-being and the flourishing of our population. And this is significant to me as somebody who likes to think about history when I think about the law, because this happened at a time when our country was primarily an agrarian country. We were not a country of inventors and philosophers and entertainers and movie makers and so forth. Most of our wealth came from our land. And yet the founders, the framers of the Constitution, felt it so important that we protect copyright, that we protect patents and the inventions that flow from them, that was one of the first things enshrined in the Constitution. So as we mentioned in the introduction, the reason we protect intellectual property is to stimulate both creation and distribution of the goods that are created as a result of that protection. So it's not just the creation, and people will tell you, especially in the arts, artists are driven to create. You don't need to give them property rights in their work to have them create. They're going to create anyway. It's part of their nature. It's part of their drive, their psyche. That may be true, but they're unlikely to be able to do so professionally. They're unlikely to be able to do so at a caliber that we would all want to consume and invest money in and support and learn from and build cultures around. And more importantly, they're not likely to feel comfortable or have the means to distribute those works in any meaningful fashion unless there are adequate protections around those works. And the protections apply not just to the artist, but often to partners the artist works with in creating the works and in getting them out to the public. When you distribute a work, of course, it puts not only the work out to the public in a way that the public can appreciate it, consume it, interact with you as an artist, but it puts the artist a little bit at risk. Somebody might take the work, might modify the work in a way, especially now in the internet world, in a way that you're not comfortable with, might change the context and the meaning of the work, might take the work for themselves, might put the work out there with their own, name on it, might distribute the work without returning any royalties or profits to you. So intellectual property protections attach to give artists and the businesses that work with artists the security and the control over their works, and also control over their dignity and the dignity of their works that ensure that they will feel comfortable putting their works out into the marketplace of ideas. So that's just a very high and philosophical approach to why we have intellectual property protections and why we feel that they're important. I'll say just one quick word also about maybe the differences between the EU particularly, and the US, again, at a very, very high level, and we can delve into the specific proposals that are on the table, both in the US and in the European Union as we get into questions in the panel discussion portion. But one thing that people often say in the United States is, oh, we don't have moral rights in the United States for copyright. So moral rights are something that in the European tradition are rights that are intended to protect really the dignity of the author, the dignity of the work. They are rights that are not purely copyright, but they prevent others from modifying a work, from distributing a work without attribution, without proper attribution, and so forth. Those are the same sorts of dignities that I talked about that are important, I think, to artists all around the world. The United States does have a requirement under international copyright treaties to respect moral rights and enshrine moral rights, but we don't do so quite as articulately, perhaps, as our European counterparts, and it isn't necessarily something that comes top of mind to our legislators, but I can guarantee you that it's something that artists constantly talk about and think about when I interact with them. So just as something as a policy-making issue that comes up on both shores, it's something that I can guarantee is important to artists around the world, regardless of how it's articulated in the law.
Thank you, Gina, from your standpoint.
Great. Well, I'm going to focus slightly more narrowly. So Sandra talked about copyright and noted importantly that IP rights are important for creation and distribution, and we look at copyright in that way. I'm going to look at sort of say a few words about patents, which are similarly important for innovation and delivery of new inventions. What I wanted to focus on today, though, is a little more narrowly the specific kind of basket of IP protections that are important to the pharmaceutical industry in particular. So talking about what it takes to bring a new medicine to market and why IP protections are so important, and where we see some reforms going in that area right now, particularly in the EU. I thought to put it in context, I talk a little bit about why sort of the impact of IP rights to the innovative pharmaceutical industry and why there are certain protections set out the way they are. So in general, the patent protection term, which is defined in our international treaties as well, is 20 years. So you receive patents. in order to incentivize you to invent and then bring that invention to market. The pharmaceutical industry, and there's a lot of high-tech industries that require a lot of research and development. I want to focus the pharmaceutical industry in particular, perhaps more than any other, really has an exceptionally long R&D life cycle that makes this 20-year protection, but also a basket of incentives around the patent protection, both in the US and EU, so important. Just to put some context to it, less than 12% of drug patents that are entering into clinical trials, and you need to have clinical trials to show safety and efficacy in order to bring medicines to patients, to use them on patients. Less than 12% of drug patents entering clinical trials are approved as a new medicine. So you start out with a lot of patents, you narrow that down to what enters into clinical trials, and then in the clinical trial or the regulatory phase, it can take an average of about 15 years, sometimes even more, to develop and secure the approval of that new drug. So to actually go from identifying the new entity to doing the clinical testing to getting the regulatory approval to actually marketing the new drug. So that can eat up a significant part of your patent protection. And at the same time, it's quite expensive to develop a new drug and bring it to new market. And so you're investing a significant amount of both time and resources. But of course, we want innovative new medicines. We want the cures. And it's not just about the financial incentive, but it's particularly important, obviously, for patients. If you look at it on the financial side, it's risky. 2 of every 10 marketed medicines achieve or match what was spent on an R&D. At the same time, once there is a new medicine and all of this investment does bring significant benefits to the economy, this is both in the US and the EU, as well as other places where there's drug development, but the US and the EU are both leaders in drug development and delivery of new medicines. And most importantly, it's the benefits to patients. And so you can't, without all of this incentivizing, it's very hard not just to get the new cure, but to the new treatment, the new way to improve that cure. One study says that between 1950 and 2014, the life expectancy has increased by over a decade. And that the vast majority of that is contributed to new medicines. So, this is sometimes I feel like in the intellectual property world, and I've been working on these issues both as an IP negotiator at USTR, at the US Chamber, and now for clients across a range of industries. It's hard to when people pit IP against innovation or against patient access or patient welfare. In the reality, when you look at some of these numbers about improving patients' lives, this is really what it's all about and why IP protection is so important. So I just wanted to take a step back and frame that for the broader discussion in the comments. I think in one of the areas we'll talk about a little more is that in Europe, there's a review right now on incentives for bringing new medicines to patients. It was launched in 2016, and we can get into the details, but there's one piece of it that's being moved a lot faster than the others, and I think there's some concern about whether in looking at these incentives, they're actually going to end up disincentivizing the innovation through some of the reforms that are being looked at, and I think that's one, kind of putting in context why IP protection is so important, and then looking at these incentives is one area for discussion today.
Definitely. So I'd like to focus first on the economic impacts in a broader sense. When we're talking about changing the status quo, changing the certain regulations or IP rights in a broad context, how are the costs going to be distributed? Who do the costs fall on? Is it the costs for investors? Is it the cost for creators in your sector, maybe, Sandra? Or is it the cost on end users and patients, as you mentioned the patients, Gina? Could you shed a little bit of light on that? And also, is there a cost to government budgets? I'm thinking of your sector as well, Gina, in this field. Will that change fundamentally? Is that a consideration that is taken up in these debates?
So I'll start, I guess, by saying I think whenever a policymaker, whether in Europe or in the United States, looks at intellectual property issues, I think people of goodwill and good intention try and come with balanced solutions that take into account everybody's interests and come with an answer that spreads the risk and spreads the burden as evenly as possible. That's sometimes quite hard to achieve, of course. And if you are a member of the industry that's affected, or if you are a member of the public who wants easy and free access to works or to medicine or to whatever the protected aspect is, you may have a different view of what is balanced than the parties against whom you are negotiating or lobbying or what have you. That's just common sense, right? So I'll give an example of what's going on in the US and what's going on in the EU in the copyright sector that maybe illustrates this a little bit. In the United States, for the last several years, we've had a comprehensive review of the Copyright Act. We've had several years' worth of hearings about every aspect of the Copyright Act, and this is the first time in like 40 years that we've had such a comprehensive review. And one of the issues that has come up repeatedly from the creative sector, and in particular from individual artists, is this concept of, in Europe it's being called the value gap, and I think that's also something that's being adopted here to some degree, and that is that when you distribute your work digitally in particular, it's very easy for the work to be picked up by others and to be posted on user-generated content sites such as YouTube and sites like that. And those sites then drive revenue from generating ads against the work, and sometimes they give the option to the artist to take the work down or to monetize the work, leave it up. But the royalties that the artist gets from the work are way, way lower than what the artist would get if the work was being licensed through a normal distribution channel rather than being uploaded by others who are not licensed to distribute the work for the artist, and the artist is put in a position of having to either issue notices to take the work down or submit to a license under terms that they don't really have the wherewithal to negotiate. So this is being called the value gap, and there's this interplay between what are in the United States safe harbors under the Digital Millennium Copyright Act, which allow internet service providers to avoid monitoring their platforms and avoid liabilities for infringing works appearing on their platforms if they merely respond expeditiously to notices that copyright owners send them and take down the works when they're notified that a work has been uploaded without authorization. Similar safe harbors exist in the EU and under the e-commerce directive that the EU passed in 2000. And so what's happening now in the EU is that there is a proposal that search engines and online markets and other what are referred to as ISSPs, Information Society Service Providers in the EU, should take a more active role and use effective content recognition technologies on their platforms and do some reporting also about the use of those technologies to rights holders. There's been heavy, heavy lobbying about this proposal, and just recently, a few weeks ago, there was a new version of this value gap proposal issued in Europe, and it's become narrower, and we'll see whether the proposal is actually ever adopted or not. But that's what's happening in the EU. In the United States, there's been a lot of lobbying, a lot of discussion, a lot of proceedings in the US Patent and Trademark Office, the Copyright Office, before Congress, but no proposals have been introduced, and I'm very skeptical that any will be. So.
I would say in the U.S., excuse me, in the EU, generally both systems recognize the same types of protections and have been leaders in promoting the types of protections needed to fuel medical research and the development and delivery of new cures and medicines. So in addition to patent protection, both countries also have a system of providing what we call patent term restoration here in the US, and it's called supplemental protection certificates in Europe, essentially, which allows for, as I mentioned earlier, you have the patent protection period, which also ends up running out quite a bit while you're waiting to get your new drug approved and doing all the clinical trials. So both systems account for that, and they provide other incentives, including an extension, essentially, of the patent term to account for the fact that a lot of time gets eaten up in approving the medicine, which is an important process because you want our medicines to be safe and effective. And both territories also have something else called regulatory data protection. So it's this combination of these rights that ensure that new medicines feel incentivized. This has been important because I think the US and Europe have both been leaders in R&D. They've also had a significant number of jobs, contributing to higher paying jobs in both economies in terms of medical innovation, investment in both areas. And also, again, as I said earlier, with patients and increased life expectancy. So when you ask who gets harmed by the costs, given these have been really among the two leading territories of with this robust package, some of which is mandated by our international treaties and a few pieces of it are not, this package is really important. It's been what's driving investment decisions. It's been what's driving these higher paying R&D jobs. So on the economic side, who gets harmed is, I do think that the nature of the IP protections granted is an important investment factor considered by companies when looking to set up their operations and to employ people. But as I said earlier, it's also patients that get impacted as well. One study found that, so this gets back to access, which we'll talk about in a minute, the EU incentive study, but one study from 2014 found that firms that launch innovative medicines sooner, that they will launch innovative medicines sooner in countries where there's an effective patent protection and enforcement system. So that's important too. It's not just about the economy and jobs, which is very important, but importantly, incentivizing those innovations and getting them launched sooner. So efforts that would look to erode those protections, these two areas which in the US and the EU, which have traditionally been aligned on these issues, is something that I think does keep some of my clients up at night, and I know has implications for other industries as well. And just to add a little more detail on what's being considered in the EU. So as I said, in 2016, the Commission launched a series of studies on patient access and the incentives for pharmaceutical development. One particular piece of that that is moving faster, I'd say, than the others is what I just mentioned, something called a supplemental protection certificate, an SPC. I don't want to get too into the weeds on it, but the SPC, when it was introduced in the 90s, European Commission itself acknowledged the importance of providing some term of extension of the patent term to account for all of these delays that we talked about from the regulatory process, and said that this was really important to incentivize the development of new medicines, and also to make sure that the pharmaceutical industry isn't penalized for having such an extensive and lengthy R&D cycle. So the EU right now there may be a proposal coming out as soon as next week or within the next month related to the SPCs, which could allow for some erosion of the patent term, this SPC extension term, that would allow some erosion of that to provide an opportunity for companies that aren't the patent holder to produce what we call stockpiling, so to produce medicines to hold for export. That is a change in the bargain that, when innovators came and they've been investing heavily in R&D in the US and the EU, they not only had your normal patent bargain of 20 years of exclusive rights, and then in return you can have all of our information and we'll lose our exclusivity after 20 years, but there was the rest of this package of protections to incentivize the development of a really risky process. And so I think changes can really change the calculus, going back to, it's a long way of going back to your question of who bears the cost. I mean, I think in terms of investment decisions and patient access, it'll have implications.
Right. So if we're talking about such changes, I guess in both your very different industries or sectors, the issue is completely framed differently. The time frames are different in the copyrights area. I understand from this time of 20 years is very different in your sector, Sandra. So is that the crux of the matter at in an era where innovation is rife and time seems to be accelerating ever and ever, is that really the issue we should be looking at? Is this time frame or the specific go-to-market time the most important matter, or are there other considerations that you'd like to bring in that play a more important role for the creators of these goods in both your sectors?
So there's often discussion about the time of protection in copyright, which is 70 years after the death of the author. And that sounds like a terrifically long period of protection if you think about it, right? But you have to think of it in context. First of all, the scope of protection is not complete, right? There are all sorts of exceptions and limitations, and you're protecting only the original authorship, the expression of the idea, not the idea itself, and you're not protecting, stock elements of a work and so forth. So it's not as if the complete entirety of what one thinks of as a work would be actually protected. If that were the case, we would not have the ability to continue building and building upon works. And there are, important exceptions like the fair use exception, which allows for the use of works in various contexts, particularly criticism and commentary and so forth. But setting the timing aside, which I frankly think is a bit of a red herring, because timing in the internet world is like 2 seconds. Once the work is out there, if it's not adequately protected, then it's lost. So I think there are a lot of other considerations beyond timing that go into having an effective regime in the digital world, for sure.
Yeah, I would agree. I mean, in the patent world, 20 years isn't that long. So these other, in the grand scheme of things, when you look at the R&D cycle, so these other protections around it, which are not that many years beyond, are very important. So yes, the years are important, but there's a lot of other factors go in, which is how well are the laws enforced? Is there a early, system to make sure that you don't allow infringing goods on the market early? And I think there's, it's not always about, are we talking a matter of months or days, but I think it's really important to look at it also from a precedential value, especially when you have two markets like the US and the EU that have been leaders in innovation, to make sure that any erosion of not just the term but the rights that come around it, that also facilitate the ability for others to ultimately produce and copy these drugs. All of that's important, and if you start to erode it, it sends a bad message, I think, to other countries that have been less committed to such protections.
Yeah. And one thing that I'll also say, and this is in particular true with some of the provisions of the Digital Single Market Directive in Europe, is predictability is always important to investors and to companies going into business. And one way that you can control predictability is by having contracts amongst the affected parties and by setting the terms of your business the way that you want to set them. And there are certain provisions in the Digital Single Market Directive which are, exceptions that you can't contract around, and then layer on top of that the fact that you've got the European Court of Justice, interpreting those exceptions that we haven't tested yet in ways that we can't predict. That gives some sense of concern to companies who might be otherwise, more excited about certain investments, I would think.
Right, so there seems to me that there's a transition period which is often quite long in the switch over to two different IP regimes, or whenever a regulation comes in place, there is a long period of assessment, consultation, etc., to bring this about. Is that a source of uncertainty that we should be trying, governments should be trying to reduce? Or should, in this period of very fast innovation, is legal certainty the main objective to be achieved in this field?
Go ahead.
I mean, legal certainty is very important. I think we've had these systems developing over decades or longer now, so there's certainly having a robust dialogue around incentives or how to always improve our system is, we never stifle stakeholder dialogue or debate. I think sometimes IP issues get a little politicized and for sort of shorter term gain, and so then there's a discussion around where the government documents might come out more politicized to sort of suggest that IP hinders innovation. And I think that's when governments start to do that, that kind of comes back. That seems counter to the goals that, for instance, both the U.S. and the EU have been pursuing in their trade agreements, to the stated purposes of the laws and rules before. But I think if in a stakeholder process, it's critical that you do look at the cost-benefit analysis of introducing a new change. And I think, so for instance, in the case of this particular incentives review, trying to carve off this one small piece on the SPC issue, where really I think there's still studies being done, and a better assessment that needs to be done on the cost-benefit analysis is really critical before you make knee-jerk changes because of the rapidly changing technology and short-term dislocations, but to make sure you're looking at the big picture and really taking a close look at the cost-benefit analysis.
Yeah, I mean, I think in any policy-making exercise, you need to look at things with a long view and then re-examine them looking back and see if you've accomplished what you intended to accomplish. And I think you're seeing that both on the Digital Single Market Directive and the Value Gap proposal, and here in the United States with the review of the Copyright Act, and in particular looking at some of the concerns about the safe harbors for user-generated content sites in particular. And I think there, what you're hearing from the creative sector is, look, 21, 22 years ago, whenever the DMCA passed here in the United States, we thought we had struck a balance that would be fair and that would incentivize innovation in the digital marketplace by creating these safe harbors and allowing new tech startups to really grow quickly and create these great new services that everybody wanted, by not forcing them to do intrusive screening and make sure that they're not putting out that they're not inadvertently hosting infringing material on their sites. But as the system has evolved, and as you see that the real kind of players now they're not tiny little startups. It's YouTube. YouTube has huge revenues as compared to even the biggest content players that they're negotiating with, and the mismatch of negotiating power and the mismatch of the burden of enforcement over time has just changed from what anybody expected. And so now I think people are going back into those debates, and the same issues exist as existed 20 whatever years ago. Still there's a concern on the part of internet service providers and services, online services, that they not be burdened with obligations that are going to slow down their innovation and slow down their ability to develop new products and so forth, or reduce their revenues. And on the other hand, creators are concerned that they not be shouldering the entire burden of policing all these new platforms, which they aren't, the best suited to understand how they work and how to find their work on all of these platforms. And you're back at the drawing board trying to resolve, these same concerns again. So,
definitely. One other development that I wanted to touch upon is the extension of global value chains around the world. When talking to you both, I realized that that was really a transformation that had impacted both your sectors quite differently. And I'd like you to bring up a few examples of that and how this ties into the whole issues related to IP and enforcement of those rights.
Sure. I mean, I think a lot of times people think about global value chains more in the context, the manufacturing context, right? But global value chains are equally important in the context of creating IP. If you think of something, probably the easiest thing to think about is like motion pictures. If you think of what goes into making a motion picture, you go from, the idea, the book perhaps, that gets turned into a screenplay that then, gets picked up by the motion picture studio, and the studio determines where it's going to shoot the production, and that production may take place in several different countries or in several different states, and employs any number of people, not just as actors and directors and producers and so forth, but people to build the sets and to do the costuming and do the makeup and all of those sorts of things. And then beyond just the creative industry that you think of, there are all sorts of other industries that come into it. Trucking, all of the material that's needed to create this, lighting, all of the catering that goes on around production, all of the housing for people who are traveling, all of the travel for all the people who are traveling. So it's a very, and so that's a motion picture example. But the same thing happens with small businesses. So a photographer doing a fashion shoot or a commercial shoot does the same thing on a smaller scale. He or she may employ an assistant to help carry all the equipment and to help light and direct the shoot. They'll employ someone to do makeup and to set up the shoot. They'll probably have to rent a location to do the shoot. And they'll, likely have to employ somebody to, help do the dressing of the scenery. They'll employ dry cleaner services or whatever other services. So it's the same sort of thing. One piece of intellectual property can generate a great deal of value in a variety of other industries as well.
I would just add, I think in the pharmaceutical space, the supply chains can get very complicated and very expanded, and manufacturing can happen in a lot of different places. But ultimately, the biggest issue is from the start, where are you going to be able to do your R&D? And ultimately, when you deliver your innovations, are they going to be protected? And I think that's where we are seeing changes where the US and the EU have been leaders, often in protection. But some other developing economies and more emerging economies are, in some cases they want to undermine IP, but in other places we're seeing some improvements. And some people are always surprised to hear, in China there's an actual slate of reforms being proposed right now that are quite robust and don't include some of the exceptions that are being looked at right now actually in the EU. And so I think when you think about supply chains and where companies are going to invest and do their development, that's why the IP protections matter so much.
Definitely, and that ties into the question of location of activities around the world. So would you say that, maybe this is very different from one sector to the other, but would you say that IP protection is a decisive factor in the decision to locate somewhere or part of your global value chain somewhere? Or is it a less important factor depending on the two sectors you looked at primarily?
I mean,
So
for
I
the
think
pharmaceutical
for-
industry, I'm sorry
yeah,
to say,
you
the
already
IP is
answered
the
that.
lifeblood
Yeah.
of their economy, their industry. So.
Cassandra?
Yeah, I mean, it's certainly, I mean, in the copyright industry, the copyright is what you have, right? So if it's not protected, you literally have nothing. But certainly, other factors also come into deciding, where you're going to locate a production, for instance, whether you have tax benefits or whether there are certain burdensome requirements of, employing particular numbers of local, population to do a shoot or what have you, or if there are market access restrictions or things of that nature, that all factors into what's possible for production, but certainly IP is critical.
Yeah. If I could just add, I mean, just a context on that, when we talk about what would the real world impact be of less IP protection, in the context of this incentives review in Europe, I mean, there's been some studies that have come out and talked about the impact that an SPC manufacturing exemption would actually lead to. And it can lead to significant, they're projecting significant job losses of over 2.27 billion to the European, in terms of losses, financial losses, over 2.27 billion to the European innovative pharmaceutical industry, losses of jobs between 4,500 to 7,700 jobs, just by one simple change alone. And those are the direct jobs, the higher paying jobs, and not including the indirect jobs. So I think as these studies help point out, there can be real losses, and that leads to real investment decisions.
I'll now turn to the audience to see if you have some questions at the back, please. Could you introduce yourself and then ask the question?
Yeah, my name is Roger Cochetti. I work with private equity in the technology sector, and if it's okay, I'd like to raise a level of discussion, kind of a layer of abstraction. Anyone who has done business in developing countries knows that the principal pushback you get in intellectual property conversations is not, oh, you've misinterpreted section such and such of the WIPO treaty, or no, you don't, the FTA does not say that. The principal pushback is ethical and ideological. And I wanted to relay to you what I have heard dozens of times, which you've probably heard yourself if you've ever attended an international meeting, and ask you to give us some fuel to respond. First, this is exactly what the United States did to England. And, through the middle of the 19th century, the United States didn't recognize British patents or copyrights, and until we got rich, we could care less about European copyrights. So we're doing to you what you did to England. Second, if every pharmaceutical patent in the world was held by Nigerians and Americans had to pay royalties to the Nigerians for all their drugs, how would the American people feel, and how would American politicians deal with it? So, these are not legal, these are ethical, ideological responses, and that's really the pushback that American companies face. So I want to give you a chance to comment on that. Thanks.
Yeah, so on the copyright issue, it is something that, a comment that's often heard, and I would urge people in developing countries to look at it not from a United States perspective, but from their local markets perspective, because if you're not providing adequate protection for intellectual property, you're not providing it for your own creators, and those creators are not able to build a marketplace for their works. And in fact, they are forced to compete against, slick Western movies or music or what have you, instead of having the ability to, compete on a more level playing field in a marketplace where, their work is valued. And one thing that, always strikes me is even in countries that I'll say aren't developing countries, but countries like India, for instance, where there are copyright protections, but they're not adequately enforced, nor are they truly enforceable when it comes to finding somebody with the deep enough pocket to enforce against. You're not going to enforce against the street vendor who's selling DVDs in the marketplace. That's not practical, and frankly, almost feels unethical, right? At that level of poverty that you're dealing with. But what is striking to me is, Bollywood is this huge industry, and there is a great marketplace in the US and in the UK of people who want Bollywood films and would pay for Bollywood films if they weren't, freely available on the internet and, cheap ripped off versions on DVDs. So they're harming, their industry more than they are harming the US industry. So that would be my response.
Well, it's funny. When I was at the chamber, we did a program, and there was a Bollywood producer who came with us over to Geneva to explain this to policymakers, that this is not just a U.S. issue. We want to, earn an investment for our creativity as well. earn a return. On the pharmaceutical side, I think what is interesting, going back to the China example I used, is that as countries get more innovative, their own sectors are starting to realize why IP protection is so important. Change often doesn't come around. As much as we'd like to say, if the U.S. says you need to do it, then of course a country is going to do it, but that's not the case. I think real change comes when the innovators and creators in a country are pushing because of their own inventions, and so that's not just a Bollywood example, but I think China's own, companies that are starting to develop their own medicines.
Any other questions from the audience? So, if not, as we get into more international examples, how important to your sectors are the bilateral dialogues or international dialogues with other partners around the world? How does this contribute to ensuring this level playing field for everyone?
Incredibly important. We're living in a digital world, and there aren't borders in digital worlds. Things don't stop, at the big border wall at the edge of the United States. So when you're talking about the internet, sorry for my sarcasm, so we need to have some sort of understanding of, commonality of IP protection in order to do effective business deals and to effectively distribute works around the world. Otherwise, it makes it very difficult to figure out, how you operate in an interconnected world.
Mm-hmm. Yeah, I would agree. Very important. We have the TRIPS agreement under the WTO, that was negotiated in 1994. So those are baseline rules that are really important. Our trade agreements build upon those, and I think that's why even when there are certain rules that aren't in TRIPS but have developed in our own trade agreements, such as patent term restoration, like we talked about, which is in U.S. agreements and in some Europe agreements. Those are really important because they continue to build the body of standards as we've developed over, the last few decades. And I think, what the two countries do, how they continue to evolve with these standards is really important, sends a strong message to other countries. There's, I think, some concern that although manufacturing for export during the patent term restoration period is not covered by TRIPS, there are countries that have put up proposals that I think they see the EU looking at this and they say, well, great, we want to do this and we want to do it during the patent term, which we've seen cases on in the WTO, and then that was struck down by the WTO, found that wasn't permitted under TRIPS. So these agreements are really important baselines, and I think it's important that we continue to find ways to build upon them.
Great. I'm very indebted to both our speakers for this conversation on two very different sectors. As you saw and you understood from the conversation, these issues span a variety of sectors and subsectors of our economies and are very important to the vitality and dynamism of the economy. So I'm very grateful to both of you, Gina and Sandra, for this for contributing to this panel this morning. Please give a hand of applause to our speakers.
Thank you. Thank you for the time.
Minutes intermission, and then we'll resume. Okay.
Okay, thank you all for your continued attendance and interest in the panels this morning. We move to our keynote speech, which today is going to be given by the Ambassador of the European Union to the United States, Ambassador David O'Sullivan. And he will wrap up the issues and transition us also into a discussion on transatlantic trade. It's my great honor to welcome and introduce the ambassador. He started his career in the Irish government some time ago. Was it maybe a decade or two? And then has had a distinguished career in Brussels. Among many other things, was the head of the Prodi cabinet when Mr. Prodi was the president of the Commission, was also the EU chief negotiator in the Doha round, and most recently, like the rest of us, has had an opportunity to do some time travel back to the 1950s and talk about steel and aluminium tariffs. The ambassador will speak for about 15 minutes, will not take questions afterwards, and so with that, I'll get out of his way. Please help me welcome the ambassador.
Well, thank you very much, and I'm delighted to be here. Thank you for the opportunity to address you. I've just flown in from a few days in Wyoming and South Dakota, where it was extremely cold, and I fear I've caught some of that cold, so I hope my voice will hold up. When I was in South Dakota on Monday, Governor Dugard introduced his remarks by saying there was no such thing as bad weather, only inappropriate clothing. Clearly, my clothing was inappropriate. But I am delighted to be here and have this opportunity to address you with a few thoughts for the Spring EuroGrowth Conference, which kicks off a series of high-level discussions and talks running up to the spring meetings of the World Bank and the IMF. And I am, as ever, very grateful to the Atlantic Council for their continued interest in transatlantic relations and for continuing to put European issues on the agenda in Washington. As you may be aware, we will have a considerable influx of senior European leaders on this occasion. They do travel regularly, but next week we will have 4 commissioners, including Vice President Dombrovskis, Pierre Moscovici, Johannes Hahn, and Commissioner Mimica, responsible for development. We also have someone who's been a lot in the news recently, Competition Commissioner Margrethe Vestager. You should note, by the way, to pronounce it, it's Vestager, not Vestager, if you like to show a little expertise in these areas. And she'll be meeting the competition authorities this week. So we're having quite a considerable through flow of European politicians in this week and next. Looking at the bigger picture of transatlantic relations these days, I think it is true to say that we really do have a hugely important relationship across the Atlantic. As Assistant Secretary of State for European Affairs Wes Mitchell said in his speech last week, where I was on a panel commemorating the 70th anniversary of the signing of the Marshall Plan into U.S. law, we're very good at celebrating anniversaries. Last year was the 70th anniversary of the announcement of the Marshall Plan. This year was the 70th anniversary of the signing of the Marshall Plan. So we believe that you can celebrate many things, the same event many times over. But this was a significant moment, and Wes Mitchell underlined that America's commitment to peace and prosperity in Europe, which was a foundation of the wider multilateral approach, had ultimately engineered the great Western economic miracle of the post-war period. And I think that is very, very true, and a considerable expansion of American national wealth. I don't want to diminish or to take from the sacrifice or the sense of solidarity which America showed both through 2 world wars but also through the Marshall Plan, which was a considerable sum of money which was made available to the European countries. But let us be very frank, there was also an element of enlightened self-interest in that, and it was also the stability and the prosperity and the growth which followed in the subsequent period was also very much to the well-being of the United States. Wes also added that with this united strength, we've managed to resist the Soviet Union until its demise. And I think this is very true. History has shown that America is stronger when Europe is united, strong, and prosperous. Now, I'm 3.5 years in this job, and I've spent, I think, the first 3 years of that time, it seemed to me, frequently on this platform, pushing back against the notion that Europe was falling apart, that the euro was going to collapse, that Greece was going to leave the euro, that we were going to be overwhelmed by refugees, by terrorism, by Brexit. I think I can finally say that these days the news out of Europe is actually broadly positive. The economic fundamentals are good, and as President Juncker said in a recent speech to the European Parliament, there is a sense in which we have the wind in our sails. Our economy grew by 2.5% in 2017, just a little over the US economy. We're taking advantage of the positive economic cycle to continue our efforts to reduce public deficit and debt. In 2017, general EU government deficit is expected to reach 1.2%, which is a historic low. Unemployment has fallen from double digits to single digits. And we are seeing a remarked economic turnaround, particularly in those countries who've recently exited the previous bailout programs, Ireland, Spain, Portugal, and also, I dare say, Greece. This is the result of some fairly tough and difficult decisions that have been taken in all our countries. But I think that we are now on a much more positive trajectory. And it shows that you can have growth with sound public finance and without increasing the burden for next generations. EU debt to GDP ratio remains high, but declined to 79.8 in 2017. And we will continue to take advantage of the positive macroeconomic environment in order to improve our position. When it comes to EU-US trade, I mean, many of you have heard me say this so many times, but it bears repetition, so I'm going to say it again. The Transatlantic corridor is the single most important economic corridor in the world, bar none. We trade and invest with each other far more than we do with any other trading partner. And I think it's important to bear in mind that I also believe that that partnership is fair and balanced. I believe that the American economy is an extremely open, relatively low tariff economy, rules-based. I believe the European Union economy is relatively low tariff, open, and rules-based. I think we are each amongst the most transparent and the fairest trading partners to be found anywhere in the world. Of course, we have a huge amount of trade. We trade about $1.7 billion a day. And if you want to look for some problems, we will always find them. We have not lacked on occasions for problems between us, but they are minor compared to the big picture of just how much we trade and invest across the Atlantic. 80% of foreign direct investment in the United States comes from European Union member states. We create across the Atlantic 15 million jobs between us in both trade and investment. And when I look at the extent of this investment, particularly this investment relationship, even more so than the trade investment, a very high proportion of trade across the Atlantic is actually intra-company trade. Companies trading goods across the Atlantic in order to manufacture in Europe or manufacture in America, but frequently on the basis of inputs coming from one or the other side of the Atlantic. And most of our companies are operating, frankly, on a transatlantic basis rather than on an American or a European basis. And this is something that we should not lose sight of. We're also the largest market for U.S. exporters. 44 out of 50 U.S. states export more to the EU than they do to China. So creating barriers to the flow of transatlantic trade and investment would be detrimental to growth and jobs on both sides of the Atlantic and affect the global economy. We believe that we should be taking advantage of the current positive macroeconomic context worldwide to strengthen the current economic expansion, address unemployment, and deepen Europe's financial architecture. Reforms on both sides of the Atlantic could and should be pursued to boost potential growth and strengthen the resilience of our economies. We should strive to limit economic uncertainty by avoiding protectionist risks, keeping the right financial buffers in place, and ensuring sound public finance. We have, as I say, broadly speaking, recovered from the financial crisis. All our member states report positive growth, and as a whole, we're entering our 16th consecutive year of growth. The crisis affected our side of the Atlantic harshly, despite its origins here. We should strive to limit economic uncertainty by avoiding any talk of protectionism. We've seen the volatility of markets as they have reacted to the uncertainty and fears over potential trade restrictions. Restrictions and fears that may in turn affect investment and even production. Of course, in this context, we regret the decision of the US administration to impose import tariffs on steel and aluminium, or aluminum as you like to call it on this side of the Atlantic. You say tomato, we say tomato. We welcome the subsequent decision to temporarily exempt the EU from such measures, and we call for that exemption to be made permanent. Let me be very clear. We do not believe that European exports of steel and aluminium were the source of the problem or that they deserve to be in any way treated in a discriminatory fashion. We are the second largest exporter of these products by volume and the largest exporter by value of steel and aluminium to the United States. And that's for a very good reason. A lot of European exports are very high quality, specialized niche products which American companies need as inputs to their other production facilities. And we do not see how this could in any way be considered a threat to US national security, either in the narrow political sense of that term or even in a broader economic sense of that term. While the US is still discussing this issue, we will continue to ensure that the interests of the EU are fully protected, and we will reserve the rights of the European Union in compliance with WTO rules to respond as appropriate and in a proportionate manner if ever the tariffs were to be applied to our exporters. We believe deeply in open trade, free and fair trade. We are not naive free traders. We know that trade is a disruptor and that you need accompanying public policy domestically to mitigate some of the negative consequences which can flow from trade liberalization. The jobs which are created don't always happen in the region where jobs are lost, and the jobs that are created don't always happen in the sectors where jobs may be lost. And this needs accompanying public policy to help maximize the benefits from trade. But we do believe that balanced trade deals are win-win outcomes. We have just concluded a very comprehensive deal with Canada. We are upgrading our first generation free trade agreement with Mexico to bring it into line with the kind of deal we've just done with Canada. We are about to sign in the next few months a very comprehensive deal with Japan, which will actually be the largest free trade deal ever concluded, representing 30% of world GDP. And we have ongoing negotiations with Mercosur and in the ASEAN region, complementing the two agreements we have reached with Singapore and Japan. I want to make it very clear that when Cecilia Malmström, our trade negotiator, commissioner, finishes her agenda with the mandate of this commission in November of next year, with all of these deals concluded, the European Union, adding to that the deals we already have, we will be at the center of the largest free trade network the world has ever seen. And this in spite of the fact that we also have some domestic concerns about balanced trade and free trade, but there is a strong commitment in Europe to keeping markets open, and we in Europe are profoundly convinced that constructive and well-crafted trade deals do give win-win outcomes for both parties. So our trade policy is about creating economic opportunities, enforcing trade rules better, and upholding high standards and values. President Trump has highlighted the need for fair trade, and we can agree with that. Trade should not be a race to the bottom, and we believe trade agreements should include high standards, social and environmental standards, protection of intellectual property rights, data protection and privacy, and food safety requirements. But we will continue to pursue a robust trading policy on the basis of discussions that are open, fair, rules-based, and mutually beneficial. We seek a level playing field, and above all, we do believe in respect of the international rules of the WTO as the ultimate safeguard for keeping global trading flows moving. These are not always to our liking. We've been the victim of, or the subject of rulings against us in the WTO, But there is no doubt about it that unless we have an internationally rules-based system with a system of arbitration which enables people who feel that the rules are not being respected to have recourse to a legal remedy. Somebody famous wrote that without a remedy, there's no such thing as a right. The WTO also provides a remedy, and we believe this is an extremely precious creation of the international trading community, which needs to be preserved, protected, and developed. Now, talking about remedies and rights, let me turn briefly to violations of intellectual property rights, because this is a new area which has developed in recent years to unprecedented levels, infringements that undermine European and US economic growth and which affect the capacity of our companies to create and innovate. And we must strive through multilateral and bilateral negotiations to enhance protection and enforcement of international protections across the globe, in particular amongst our key trading partners. We must protect our copyrights and related rights, trademarks, patents, plant varieties, designs, and, yes, you know I'm going to say the words, geographical indications. We stand ready to deepen our cooperation with the US to tackle this common challenge, including focus on priority countries such as China, where we estimate 80% of seized counterfeit goods originate. I want to emphasize that in this area, as in steel and aluminium overcapacity, we very much share many of the concerns of this administration about China's behavior. And we are willing to make a common cause to try to change that behavior and to put the maximum pressure on China to address a number of problems in the global trading system for which they bear particular responsibility. Turning now to the other panel that was this morning, which was data protection. As you know, we in Europe believe that data protection and privacy are fundamental rights. I actually saw a reference to Tim Cook talking about saying that privacy was a fundamental, was a human right which was uniquely American. I must admit, I was a little surprised. I'm perfectly happy to grant it as an American human right, but I think we also in Europe are pretty far ahead in saying that data privacy is actually a fundamental right. And as a rule, personal data should not be used without the consent of the person concerned. And we have always had, going back to 1995, strong data protection rules to protect this fundamental right within the European Union. Now, this protection will become stronger with the entry into force of the new EU General Data Protection Regulation. I love our capacity to make things sound interesting, and the acronym, which is GDPR, always makes me think I'm talking about former East Germany. But anyway, such is the times we live in, that this is now passed into general parlance, and you'd be amazed how people you would never have thought would have known about the GDPR actually come up and say, "What do you think about the GDPR?" So. But this is really a comprehensive overhaul of our privacy regulations. It's not, I believe, a revolution so much as an evolution from the 1995 set of principles, but we've learned from the experience of the 20 years previously, and I think there are a number of additional safeguards and strengthening of protection based on that. Essentially, I like to call it a kind of Bill of Rights for citizens vis-a-vis their data. It will provide data subjects in Europe with new rights and more control over personal data, including to ask for the right to ask for the personal data an organization holds on you, and a clarified right to be forgotten. I want to emphasize the right to be forgotten, which is something I had a lengthy discussion on in South Dakota, is nonetheless a very, very, very small subset of this issue, and it should not be happy to discuss it, though apparently I'm not taking questions, so I won't be happy to discuss it with you. But in general, happy to discuss it, but it is sometimes, in my view, overblown as a concept, in the sense that some people interpret it as something which could undermine the transparency and the ability to track down details about people. This is not the intention. It really is a very focused and surgical instrument which can only be used in very exceptional circumstances. We have seen the growing Facebook's data breach over the past few weeks. From a European Union perspective, the unauthorized access to and further misuse of personal data belonging to Facebook users is, of course, not acceptable. Our Commissioner for Justice, Vera Jourova, said the Facebook Cambridge Analytica case is not only about the protection of personal data, it may have a huge impact on our democratic debate and on our elections. It is a wake-up call for all of us. Data protection is not an aim in itself. It is important for the quality of our democratic debate. Thankfully, we believe we have good frameworks to protect and enforce transatlantic data protection through the EU-US Umbrella Agreement and the Privacy Shield. Today, more than 2,700 entities have subscribed to Privacy Shield, a modern GDPR-compatible 21st century agreement that reinforces commitments on the handling of personal data transferred from Europe to the US and on enforcement for infringements and use. Privacy Shield has proven very successful, and we have high expectations for its durability. Last September, Commissioner Jourova conducted the first annual review jointly with Commerce Secretary Wilbur Ross, and the outcome was positive. We concluded that US continues to ensure an adequate level of protection for personal data transferred under Privacy Shield. But companies can do more to build trust with their European customers by filing transparency reports on the number of requests intelligence agencies make to access user data to ensure that they remain necessary and proportionate. And we maintain our calls for the implementation of the recommendations made during this review. This is key to the durability of the Privacy Shield framework. The big difference between the Privacy Shield and its predecessor instrument, the Safe Harbor, is the built-in review mechanism. I think the great challenge with Safe Harbor was when it was put in place in 2000, 2001, if memory serves me well, most people actually thought it was a temporary measure and it would be followed by something more developed. Because it worked, people felt nobody kind of bothered to get round to amending it or to upgrading it. And then, of course, we had the incident of Snowden and the revelations of all of that, which put some of it into question. We then knew we needed to upgrade the Privacy Shield, but the Safe Harbor, but unfortunately the court got there before us, and frankly many of the things which the court found flawed in it, we had already identified in working papers of the Commission of ways in which we should have tried to improve it. The great advantage of the Privacy Shield, apart from the fact that it kind of starts from a higher base, namely the court judgment, but also it contains an annual review mechanism, which hopefully will enable us to be able to make adjustments where new situations and new information comes to light, and we can, in partnership with our American colleagues, tweak it and improve it and adjust it so that it can become a much more durable instrument and much more resistant to potential litigation. In conclusion, I would just like to reinforce that our transatlantic relationship goes far beyond a purely mercantilist approach or the defense of national interests. Our cooperation is not a zero-sum game, and our partnership has been win-win for decades, and we have thrived together. And when I think of the depth and breadth of the transatlantic relationship, whether that is the commercial relationship, which I've already described in terms of the transatlantic corridor, the extent of commerce and investment, whether that is the security relationship, the NATO alliance, our shared commitment to common defense, but also our strong alliance on global issues to try and have common positions on issues of international concern, and the values agenda, which I constantly return to. The values of democracy, human rights, the rule of law, values which came originally from Europe, were transplanted to this continent by people fleeing persecution and autocratic regimes in Europe where they were unable to develop and flourish these ideas. They were developed, flourished, and nurtured here, and then re-imported back to Europe. The other analogy I have is when we had the great disease on the grapes in Europe, and we needed to cut down much of the vineyards, and we re-imported many of the vines from California to help regrow. This is the kind of backwards and forwards we've had between our two continents, and we should not lose sight of this, the importance of this. These are fundamental values. There are other models of cooperation and of functioning of society out there, which I think we would be less comfortable with. And our democracies are being attacked by authoritarian regimes, And we have to stand together and not lose sight of that big picture. We believe that we're assuming a huge responsibility also in global affairs. The EU and its member states fund 56% of the world total development and humanitarian assistance. And like the US in the aftermath of the Second World War, we do that because it serves both our values and our strategic interests. And we will seek to keep acting as a force for good around the globe to do our fair share when it comes to tackling global issues, from security and defense to trade, development, humanitarian aid, and climate action. And I hope that we can do that always in very close partnership with the United States. A strong Europe means a strong America. George Marshall and Harry Truman understood that perfectly. And we remain, as Vice President Biden said at the Munich Security Conference a few years ago, each other's best friend of first resort, not just in the good times, but allies when you can turn to also in the bad times. Thank you very much indeed.